So with regards to federalism and money, the federal government collecting money and then giving it out conditionally is a residual power, I suppose, acts in a way that centralizes power that may or may not be supported by the Constitution. I suppose it could be a political decision. It is worth noting though, and I guess this notes it as well, that they can't legislate in the areas that the provincial governments have power over. So looking at Edwards versus the Attorney General of Canada, this is examining the different reasonings or interpretations of the Constitution, original versus contextual, in a case where women were fighting for the right to be appointed to the Senate, or to have the Governor General to be able to appoint women to the Senate. And originally when the case came for a judge, the Chief Justice used originalism and decided that the original writers of the Constitution intended for persons to be men, and thus it is men. However, on appeal, the judiciary used a contextual approach to deciding the circumstances. And they found a number of reasons why a woman should be included in the definition of person. First of all, they noted Broham's Act of 1850, which stated that the words importing a masculine gender shall be deemed to be taken to include female gender. Now, there were some cases that followed that ignored that act, but nevertheless, the Justice Duff goes on to say that we need to take a broad understanding of the Constitution. He says that there are statutes and there are statutes, and with regards to the Constitution, we need to be the mistress of our own house and interpret it to the needs of the community. He alleges that the burden of proof should be on the party that alleges women should not be excluded. So these are some of the broader contextual ideas and interpretations that Justice Duff is bringing into the situation. With regards to internal evidence, there is an issue of qualified. You must be qualified, and that means that you had to have $4,000 in property. But according to the Married Women's Property Act, women could do that and could be thus qualified. There's also the language within the Act itself. There are a few sections, 41 and 84, where they actually say male persons. Now, if it was their intention to limit the Senate appointment to just males, they could have just said so, but they didn't. And so, the Governor General was given the opportunity to appoint women to the Senate. It's also worth considering, though, that what would have happened if they didn't. Then if they didn't allow the Governor General to appoint women, well, we may have seen a constitutional amendment. There might have been a great deal of political pressure applied to the legislatures, and yeah, so because the court was willing to interpret the Constitution based on modern ideals, we didn't have to go through the amending formula of the Constitution. Here we're talking about the rule of law, Roncarelli versus Duplessis. Very simple case. There was the Jehovah's Witnesses were calling Catholicism the whore of Babylon and spreading pamphlets all around, and the majority Catholics didn't like that very much. And so they started arresting them all, throwing them in jail. Roncarelli had lots of money and a very nice restaurant, and so he would post bail for the people who were arrested so that they could continue distributing pamphlets. Duplessis, the premier at the time, called the liquor commissioner and said, look into this guy. And on the second call, his liquor license was canceled. So he sued, of course, for what was essentially the loss of his business. Now, Duplessis in this case said, I did everything in good faith. I have an obligation to act. This person was aiding these people who were blatantly and frequently breaking the law, and so there you go. However, I shouldn't say however, the arguments continue. They say, or I suppose the dissenters in this case, say that the license is a privilege for those that qualify, and it can be taken away for any reason, including aiding and abetting these criminals. However, the majority decided that this was tantamount to fraud and corruption, and it is objectionable. The revocation, or to revoke his license on arbitrary or discretionary measures, is a gross use of power. The commissioner and the premier in this case as well went outside the limits of their role and imposed a penalty on an individual that was not justified by the statute. So there are reasons to revoke someone's liquor license that are justified by the statute, and if it becomes arbitrary, then you're undermining the principle of the rule of law. So according to this case, politicians must follow the rule of law too, and Roncarelli was awarded court costs and an additional $25,000. Manitoba language rights deals with a similar rule of law issue. Here, all acts in Manitoba must be enacted in English and French, but that was continually refused by the provincial government. They tried to pass their own act that said the acts only need to be passed in English, but that was refused by their courts, their own courts. So there was a constitutional challenge that asked whether all of the laws that were only written in English were unconstitutional and thus void because they weren't written in French and English. And in fact, the decision was that they were unconstitutional, and they gave the Manitoba government 5 years to reenact every statute in a bilingual form. The significant part of this is the rule of law, though. It did fall upon the government to follow the rule of law. So, advocates tend to read into the rule of law anything which supports their particular view of what the law should be, but the rule of law is not anything you want it to be. And they do describe a couple elements, 2 elements of the rule of law in this case, which I will review. And that's what I learned in Constitution this week.